Good morning. The case we have chosen is a case about jurisdictional immunities of states. As an example, we have taken the Germany versus Italy and Greece intervening case. So let's first talk about the subject of the dispute. As my colleague Fernando will explain later, between 2004 and 2008, the Italian Republic brought different claims against the Federal Republic of Germany. Those claims were brought to the Italian civil courts that had to issue a number of judgments in which they found Germany responsible for a series of war crimes and crimes against humanity committed by the German Reich during World War II. For those crimes, Italy ordered Germany to pay compensations to Italian plaintiffs who had fallen victim to such crimes. Those compensations are, for example, the Ferrini versus Germany case, compensation, the Manteggi versus Germany case, compensation, and the Prosecutor versus Max Joseph Milde compensation. Germany did not dispute the substance of the fact, but the 23rd of December of 2008, Germany filed an application instituting proceedings against Italy before the International Court of Justice, which is the principal judicial organ of the United Nations. What Germany was arguing is that in the recent years, Italian judicial bodies have repeatedly disregarded the jurisdictional immunity of Germany as a sovereign state, thus violating international law. But what is exactly jurisdictional immunity? Let's give a brief definition. According to a general rule of customary international law, states enjoy immunity from the jurisdiction of other states. The International Court of Justice has held that state immunity derives from the principle of sovereign equality of states, which, as Article 2.1 of the Charter of the United Nations makes clear, is one of the fundamental principles of the international legal order. Italy, on the other hand, emphasized that the underlying crimes against humanity, and war crimes were violations of jus cogens, law that is binding upon states regardless of any treaty, and since jus cogens rules always prevail over any inconsistent international law rule, the later rule of immunity of Germany must be given away. But what is exactly jus cogens? Let's give again a brief definition of it. So, jus cogens is the body of elementary rules or peremptory principles from which no derogation is permitted, those norms recognized by the international community as a whole as being fundamental to the maintenance of an international legal order and that can operate to invalidate a treaty or agreement between states to the extent of the inconsistency with any such principle or norms. Let's now see if the International Court of Justice had or no jurisdiction of the case, which was the first step of this case. So, the application was brought under the terms of the European Convention for the Peaceful Settlement of Disputes of the 29th of April of 1957. Convention that was ratified by Italy the 29th of January of 1960 and ratified by Germany on the 18th of April of 1961, and none of the two parties has denounced this ratification. So under Article 1, the high contracting parties shall submit to the judgment of the International Court of Justice all international legal disputes which may arise between them, including, in particular, those concerning any question of international law, as is stipulated in the letter B of the European Convention, and in which falls this case. Also, the applicability of the European Convention is not excluded by the provision of Article 27, which enunciates certain time limits, in which the provisions of this convention shall not apply to disputes relating to facts or situations prior to the entry into force of this convention as between the parties of the dispute. So let's make a timeline to understand if it has or not jurisdiction under this Article 27. As was already indicated when we specified the subject of the dispute, all claims which have been introduced against Germany before Italian courts related to the occurrence of World War II, before the peaceful settlement of dispute was ratified and into force by the two countries, Italy and Germany. However, the prosecuting instituted against Italy do not deal with the substance of those claims about World War II. Germany's objective was to obtain a finding from the court that to declare that the claims falling within the domestic jurisdiction of Italian court constituted a breach of international law, and those claims were between 2004 and 2011. So, those will after the European Convention enter into force as between the parties, although the court accordingly has jurisdiction to deal with the dispute.